History and Evolution of Crime and Punishment in Canada is brought to you by ProPics Canada Media Limited, ProPics AI Technologies and InVideo. Sponsored by Metro Vancouver's best local and long-distance moving company, Carey Movers. Crime and punishment. A tale as old as time itself. Canada, a nation often perceived as a beacon of peace and order, is no stranger to this complex narrative. Long before Europeans arrived, the land we now call Canada was home to diverse indigenous cultures. Each nation had its own approach to maintaining law and order, focusing on restoring balance and healing harm. These ancient methods of justice offer a unique perspective emphasizing healing and restoration over retribution. Indigenous communities had complex systems of law and governance, emphasizing a holistic approach to justice. Justice involved the entire community and included various forms of restitution and public apologies. These early justice systems were flexible and adapted to the needs of the community. The arrival of European settlers marked a significant shift in Canadian justice. European legal traditions, rooted in punitive systems, overshadowed Indigenous practices. The imposition of European laws led to the erosion of Indigenous governance and justice practices. As Canada moved towards nationhood, the fusion of European and Indigenous legal practices created a unique legal landscape. While European laws dominated, Indigenous customs were sometimes acknowledged, especially in rural areas. Today, there is an increasing effort to integrate Indigenous justice practices into the Canadian legal system. The 19th century saw significant changes in the approach to crime and punishment, with a growing emphasis on incarceration. Canada began constructing large-scale prisons, such as Kingston Penitentiary, which opened in 1835. These institutions aimed to instill discipline and reform in a rapidly changing society. Critics raised concerns about harsh conditions and the effectiveness of punitive approaches. Debates about the purpose of punishment fueled ongoing reforms and discussions about justice. Certain criminal cases gripped the nation's attention, becoming etched in Canadian crime history. The gruesome murder of Thomas Kinrod in 1876 and the tragic case of Emily Murphy in 1916 highlighted the limitations of the justice system. These cases forced Canadians to confront uncomfortable truths about their society. They became cautionary tales, reminding Canadians of the potential for darkness amidst the nation's pursuit of peace and order. A counter-movement advocating for reform began to emerge in late 19th and early 20th century Canada. Sir John Joseph Kelso, a social reformer, argued that prisons often served as breeding grounds for criminality. Kelso's advocacy led to the establishment of the Toronto Children's Aid Society and paved the way for a more humane approach to juvenile justice. The mid-20th century witnessed a profound shift in Canada's social and political landscape. The old methods of retribution were increasingly questioned, paving the way for a more humane approach to justice. Social scientists and policymakers argued for a system that addressed the root causes of criminal behavior. This period saw the rise of social welfare programs and a greater emphasis on social justice. The evolving social contract laid the groundwork for significant reforms to the criminal justice system. Landmark legal cases in the mid-20th century challenged the status quo and reshaped Canada's justice system. The case of Robert Pickton exposed systemic issues within the justice system and highlighted the need for a more responsive and equitable system. The national inquiry into missing and murdered Indigenous women and girls had far-reaching implications. These cases served as catalysts for change, exposing flaws and biases within the justice system. Canadians demanded a system that truly lived up to its promise of equality and fairness for all. The 1960s saw a spirit of reform sweep across Canada, embracing the rehabilitative ideal. The focus shifted from punishment to addressing the underlying causes of crime and providing opportunities for rehabilitation. Innovative programs within prisons aimed at education, vocational training, and addressing substance abuse and mental health issues. Parole boards were granted greater flexibility in considering early release for inmates who demonstrated progress. The rehabilitative ideal marked a significant departure from punitive approaches, reflecting a belief in the potential for human change. Section 1. The Capital Punishment Debate, an ongoing controversy. The debate over capital punishment in Canada, though resolved legally with its abolition in 1976, continues to stir public and political discourse. The movement towards abolition was marked by a shift in societal values towards human rights and the sanctity of life, reflecting broader global trends against the death penalty. This transition was not merely a legal reform, it was a profound cultural shift that questioned the morality and efficacy of taking a life as a form of punishment. Opponents of the death penalty argued that it was an irreversible and barbaric practice, incompatible with a justice system that values rehabilitation over retribution. They pointed to the risks of wrongful convictions, which could lead to irrevocable mistakes. Advocates, however, maintained that certain heinous crimes warranted the ultimate penalty, arguing it served as a deterrent against the most severe offenses. The continued interest in this debate illustrates the complex nature of public sentiment towards crime and punishment. It serves as a reminder of the ongoing struggle to balance justice with compassion and law with morality. Even though the death penalty is no longer practiced, its legacy influences contemporary discussions on punishment severity for crimes like terrorism and serial murder. The abolition of capital punishment also set the stage for Canada to enhance its reputation on the global stage as a country committed to progressive human rights practices. This has fostered international collaborations in law enforcement and criminal justice, further shaping the Canadian identity in global legal contexts. Section 2. Restorative Justice, a return to roots. Restorative justice represents a significant paradigm shift in the way Canada approaches crime and punishment. Rooted in indigenous practices, this approach focuses on the rehabilitation of offenders through reconciliation with victims and the community. This system emphasizes healing over punishment, seeking to repair the harm caused by criminal acts by engaging all stakeholders in the justice process. The implementation of restorative justice practices in modern times can be seen as an attempt to harmonize contemporary legal practices with ancient indigenous principles. It is an acknowledgement that the punitive models inherited from European legal traditions may not always provide the most effective solutions for crime and societal healing. Restorative justice has shown promising results in reducing recidivism, alleviating overcrowded prisons, and improving victim satisfaction. However, it also faces challenges, including the reluctance of traditional legal systems to fully integrate these practices and the varying degrees of crime severity with which it can be effectively employed. The ongoing development and integration of restorative justice into the Canadian legal system suggest a move towards a more compassionate and community-oriented approach to crime. This shift not only aligns with contemporary values of human rights and dignity, but also revives a part of Canada's indigenous heritage, showing a respect for its deep-rooted principles of justice. Section 3. The Digital Frontier, Cybercrime and Modern Policing. The advent of the digital age has brought about new challenges for crime and punishment, with cybercrime emerging as a significant threat. Cybercrime encompasses a wide range of illegal activities, from identity theft and financial fraud to cyberbullying and the distribution of illegal materials. The faceless, borderless nature of these crimes presents unique challenges for law enforcement and the legal system. Canada has responded to these challenges by adapting its legal framework and policing strategies. New laws have been enacted to specifically address the nuances of cybercrime, and police forces across the country have developed specialized units focused on digital crimes. These measures underscore the need for continuous adaptation in the face of technological advancement. Moreover, the fight against cybercrime has necessitated increased international cooperation. Crime knows no borders in the digital world, making global partnerships essential in tracking and prosecuting cybercriminals. This cooperation is facilitated by agreements and shared protocols among countries, highlighting the importance of international legal harmonization. As technology continues to evolve, so too will the nature of crime and the methods required to combat it. Canada's ongoing efforts to stay at the forefront of these changes not only protect its citizens but also contribute to global security initiatives. This proactive approach is vital in maintaining public trust and safety in an increasingly digital world. Section 1. Lessons Learned, Futures Forged, reflecting on Canada's justice journey. As we've journeyed through the annals of Canadian history, exploring the evolution of crime and punishment, one thing becomes abundantly clear. The pursuit of justice is an ongoing process, a tapestry woven from the threads of our past, present, and future. It's a story of triumphs and failures, of progress made and lessons learned, all shaping the very fabric of our nation. From the ancient traditions of indigenous peoples, with their emphasis on healing and restoration, to the harsh realities of early European penal systems, Canada's justice system has been a reflection of the values and anxieties of each era. We've witnessed the rise of incarceration as a dominant force, the emergence of rehabilitative ideals, and the ongoing struggle to balance individual rights with the need for public safety. The landmark cases, legal reforms, and societal shifts we've explored have left an indelible mark on the Canadian conscience, challenging us to confront uncomfortable truths about our past and to strive for a more just and equitable future. The story of crime and punishment in Canada is not merely a historical account, it's a call to action, an invitation to engage in the ongoing dialogue about how we, as a society, choose to define justice. Section 2. The Enduring Power of the Past, Shaping a More Just Future. Understanding the historical context of crime and punishment is essential for crafting effective and equitable justice policies for the future. By acknowledging past mistakes, learning from successful reforms, and recognizing the enduring impact of historical injustices, we can work towards a system that is truly just and responsive to the needs of all Canadians. The legacy of colonialism and the systemic discrimination faced by Indigenous peoples continue to cast a long shadow on the Canadian justice system. Recognizing and addressing these historical injustices is paramount to achieving reconciliation and creating a truly equitable justice system. Incorporating Indigenous perspectives, traditional knowledge, and restorative justice practices into the mainstream legal framework is essential to rectifying past wrongs and building a more inclusive future. Furthermore, we must remain vigilant in addressing contemporary challenges, such as the rise of cybercrime, the ongoing debate over sentencing disparities, and the need for greater access to justice for marginalized communities. By learning from the successes and failures of past reforms, we can develop innovative and evidence-based solutions that address the root causes of crime and promote a safer and more just society for all. The pursuit of justice is a continuous journey, not a destination. By engaging in open and honest dialogue, embracing diverse perspectives, and remaining committed to the principles of fairness, equality, and human dignity, we can create a justice system that truly reflects the values of a just and compassionate society. Section 3. Towards a Balanced Scale, Balancing Retribution with Rehabilitation. The Canadian justice system has long grappled with the tension between two fundamental objectives: retribution and rehabilitation. Retribution, often seen as the embodiment of justice served, emphasizes punishment proportionate to the crime committed. Rehabilitation, on the other hand, focuses on addressing the underlying causes of criminal behavior and providing individuals with the tools and support they need to turn their lives around. Finding the right balance between these two objectives is a complex and ongoing challenge. While the desire for retribution is understandable, particularly in cases involving heinous crimes, a solely punitive approach often fails to address the systemic issues that contribute to criminal behavior. Over-reliance on incarceration, for example, can lead to overcrowding, increased recidivism rates, and the perpetuation of cycles of crime within marginalized communities. A more holistic approach to justice requires investing in social programs, such as education, job training, mental health services, and addiction treatment. By addressing the root causes of crime such as poverty, lack of opportunity, and social exclusion, we can create a more just and equitable society that reduces crime rates and fosters greater social cohesion. Ultimately, the goal of the justice system should be to protect society while also offering individuals who have committed crimes a genuine opportunity for redemption and reintegration. Striking a balance between retribution and rehabilitation is not about being soft on crime, it's about creating a system that is both just and effective in promoting public safety and well-being. Section 4. The Unfinished Story, the Ever-Evolving Landscape of Justice. The story of crime and punishment in Canada is far from over. As our society continues to evolve, so too will the challenges facing our justice system. New technologies, changing social norms, and emerging forms of crime will continue to test the limits of our legal frameworks and demand innovative solutions. The rise of artificial intelligence, for example, presents both opportunities and challenges for the justice system. While AI has the potential to improve efficiency and fairness in areas such as sentencing and risk assessment, it also raises concerns about bias, transparency, and the potential for unintended consequences. Similarly, the increasing awareness of mental health issues and the need for trauma-informed approaches to justice will require ongoing adaptation and reform. Ensuring that the justice system is equipped to address the needs of individuals with mental health challenges, both as victims and offenders, is crucial to creating a more just and compassionate society. The pursuit of justice is an ongoing journey, a collective responsibility that demands our continued attention, critical reflection, and unwavering commitment to the principles of fairness, equality, and human dignity. By learning from the past, embracing innovation, and engaging in open and honest dialogue, we can strive to create a justice system that truly serves the needs of all Canadians. Thank you for watching. This video was brought to you by ProPics Canada Media Limited, ProPics AI Technologies, and InVideo. Sponsored by Metro Vancouver's best local and long-distance moving company, Carry Movers. Available online at www.carrymovers.com.